Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. This isn't a restaurant? Why am I talking like that? We have a very small update in Blake Lively's legal case against Justin Baldoni and the Wayfarer parties. As most of you know, the deadline for arguments over whether or not certain things will remain sealed from the public has been pushed back a couple of times. I think it was a couple of times, but the point is it's been pushed back to this month. So parties and non-parties are going to have to request for certain things to remain sealed if they don't want those things to be released and publicly available. Isabela Ferrer, who played the younger version of Lily Bloom, Blake Lively's character in It Ends With Us, came into this lawsuit in kind of a weird way a few months back. She went to the judge asking for sanctions because Justin Baldoni had been trying to serve her with a subpoena. She said that when the public was made aware that they were trying to serve her with a subpoena, she began receiving harassment, which honestly I don't doubt. People on both sides of this lawsuit are unfortunately going to receive a lot of harassment. Not everybody who watches along with this stuff is gonna harass people, but there are some strong personalities out there who would, go so far as to DM them some pretty horrible things. And back when that all happened, she claimed the subpoena was a means of harassment, which is just insane because she was actually a material witness to this stuff. So it makes sense that he would subpoena her. And then also throwing a weird fit about Justin including that message from her where she was thanking him for being such a good director and making her first experience such a good experience and a safe one, which if Blake Lively is saying that the set was so horrible and unsafe for women, I think that's kind of relevant, especially if she's bringing up Isabela Ferrer in this. We came to learn that Blake Lively had actually subpoenaed Isabela Ferrer already. So again, there's this misunderstanding that Justin Baldoni was the one to initially bring in people like Isabella and Taylor Swift, when actually Blake Lively was the one who made them relevant to this case. But Isabella is now asking for continued sealing, permanent withholding from the public. I believe it's permanent. Specific, narrowly tailored portions of certain materials. And while I think I largely disagree with a lot of the way that she or her attorneys at least have approached some of this stuff, this document in particular, I did want to go over and just point out that this is a lot more nuanced than some people might think based on gut reactions and what we've seen in the past, or just expectations and personal opinions. I don't know. I just wanted to point out why some of this is I understand why it's necessary. This should be a fairly short video. I mean, it's not a very long document. As you can see, it's 2 pages. Dear Judge Lyman, we write on behalf of non-party Isabela Ferrer to respectfully request that the court maintain the sealing of Exhibit 75 to the declaration of Alexandra Shapiro in support of the Wayfarer party's motion for summary judgment. Exhibit 10 to the declaration of Michael Gottlieb in support of Blake Lively's opposition to the Wayfarer party's motion for summary judgment. And Exhibit 124 to the Gottlieb declaration. These exhibits consist of or disclose excerpts from Ms. Ferrer's deposition testimony containing highly sensitive, confidential testimony regarding the filming of intimate scenes and discussion of another non-party's religious affiliation. The testimony was designated confidential during the deposition pursuant to the operative protective orders, and good cause exists for the sealing to remain in place. So initial reaction to that, just from my personal opinion as part of the public, my standpoint is I understand why non-party testimony might be something that doesn't need to be aired out to everybody. I think the portions that are relevant to the lawsuit, yes, that, is something that is relevant to the case and that the public should be able to see that. But when it comes to stuff like she's saying somebody's religious affiliation, another non-party's religious affiliation, I don't really think that that's something that needs to be aired out to everybody. I don't think that random people, or not even random people, even people who were on the set and who saw some of this stuff, I don't think everything about their lives and their involvement in the filming needs to be aired out to the public. I mean, what does another non-party's religious affiliation really have to do with Blake Lively's claims against Justin Baldoni? Probably not much. So that's the kind of thing where I'm yeah, I understand why, there should be protections in place for third parties. In its recent memorandum and order, the court directed parties and non-parties to explain how any proposed sealings related to the Wayfarer party's summary judgment filings is consistent with the court's framework. The sealing Ms. Ferrer seeks falls squarely within the categories of information the court identified as appropriate for protection, even at the summary judgment stage, where the presumption of public access is strongest. As the Second Circuit and this court have recognized, the privacy interests of non-parties should weigh heavily in a court's sealing analysis. Indeed, such non-party information falls within a venerable common law exception to the presumption of access, particularly where, as here, disclosure would reveal information traditionally considered private, including sensitive personal matters which are not central to the litigation and which have no public ramifications. So this is the kind of thing where I'm saying I agree some of this stuff, if it's really not relevant to the litigation at all, And if it really has no bearing on, the public, then why should that be disclosed? The courts do have to have things in place to protect non-parties. Because imagine if one of the content creators that was subpoenaed, like I was not happy when I got my bank information and all that subpoenaed, but imagine they had decided to depose someone. I don't know why they would have, but imagine they did. Then they could ask all manner of things in that deposition, and a content creator shouldn't have all their private business, their personal business, like aired out to the public for no reason at all when they had nothing to do with the litigation. So I kind of see it that way. Like, even if you don't agree with other things that Isabela Ferrer has done, or even if you don't like the non-party in question, we need to think of this as a whole, like this protecting third parties as a whole, because it applies to everyone, every third party. The portions of testimony at issue here contain sensitive details regarding the filming of intimate sexual scenes and the religious affiliation of another non-party who is not involved in this litigation. The court expressly recognized the protection of such significant and substantial privacy interests as a higher value that may overcome even a strong presumption of access. Further, the court has acknowledged the exceptional level of public and media attention surrounding the case. As a non-party who did not voluntarily choose to become involved in this litigation, Ms. Ferrer is particularly vulnerable to harassment and misuse of these sensitive excerpts, including widespread disclosures in the press and on social media. Such misuse carries an additional risk of professional harm to Ms. Ferrer, who is a working actress. Public circulation and potential distortion of intimate, highly personal testimony could negatively affect her opportunities within an industry that is uniquely sensitive to public perception. These risks fall squarely within the harms the court recognized in its memorandum and order, and they outweigh any minimal public interest in disclosure. So like I kind of mentioned before, when she called the subpoena harassment, I thought that was ridiculous. I didn't agree with that. But here they're referencing like receiving harassment online and saying basically this information is not relevant to this case, but may lead to harassment. So if it's not relevant to the case, and then it might just lead to further harassment of a non-party for like unnecessary reasons, and I can understand why that would remain redacted, My PC just had a seizure, so I'm hoping it didn't wipe out this entire recording, but we'll find out. Let me give you kind of a ridiculous example. I think about it this way. Say Isabela Ferrer talked about how red was her favorite color in her deposition, and that was released to the public, and then the public starts harassing her in her DMs saying red is your favorite color because you're Satan. Like that's that's a little weird, and there was no reason to disclose that to people, which would lead to harassment. I know favorite color is not really something that's probably going to lead to harassment. I'm just trying to come up with a very basic example of what I'm thinking to demonstrate my kind of opinion. I saw some of the messages they included in when she was complaining about the harassment and stuff in regards to the subpoena. Some of it was definitely not harassment. Like, you might find like that you don't want to talk to these people who are sending you messages, but you are a public figure with a public social media page. I mean, you're going to get comments from the public in that regard. However, some of it was intentionally, distressing to her. Some of it was intended to annoy her or to make her feel fearful or upset, and it was harassing. So like, I don't personally, I make a point of I don't send DMs to people that I don't like on the internet. I mean, I don't really think that I have any reason to be in communication with these people. So just as a rule, I wouldn't be DMing any of these people. Like, I'm not going to DM Blake Lively and be like, yo, I think your hair care line is overpriced. And also, why did you subpoena my credit card information? Like, I didn't like that she did that, but I'm not going to go, sling obscenities into her inbox. I don't want any interaction with her. Same with like a reality TV star. If I don't like a reality TV star, I'm not going to go to their DMs and be like, you're a piece of shit. Because there are people who will go so far with like not liking someone from TV or online, and they'll say like crazy stuff that's like half truths just to get under their skin, and they'll send them DMs and say stuff like, I hope you die. And it's just crazy. Like, sending someone a message saying something like, I hope you get harmed or die is a crazy thing to do. That is not well. And it's not really legal. Certain types of threats or harassment are not protected free speech. It's one thing to get a message from someone saying like, I don't necessarily like what you did and I don't agree with that and blah, blah, blah. And like, that's like, maybe you might think, okay, well, I don't really like that. I don't want to talk to this person. I'm going to block them, or I'm going to ignore their DM, or I'm not going to give them permission to continue to message me. That's one thing, right? But there is real harassment going on, and it happens to everybody involved in this lawsuit and all public lawsuits with celebrities. It happens all the time. So if you can prevent some of that by continued sealing, like sealing that her favorite color is red, so that people don't send her messages saying, I heard that you're related to Satan, then yeah, I think that is a reasonable request. However, I will also acknowledge that there's going to be stuff that some people will say is not relevant to the lawsuit, that the Wayfair parties or the Lively parties will come out and say, no, this is relevant to the lawsuit. The public should see this. And they're going to have to kind of argue that. So since I don't know the nature of the statements in question, we're going to have to wait and see, what the parties have to say about it and then what the judge ultimately decides. But I do think non-parties, should have the right to ask for these things. And I do think that non-parties should be afforded as much privacy as is appropriate. Even if I don't like them or don't like what they've done, I don't think that anybody's privacy should be violated, because if that happens, if we were to disregard privacy rights just because we didn't like the third party in question, then that opens the door for other people to actually be harassed via like subpoenas or depositions and stuff like that. Because at that point, if the privacy of non-parties is no longer going to be considered, subpoenaing someone's information or deposing them becomes a much, much, much more threatening thing. I mean, it already can feel that way. But if you're a non-party who was present for the events that are at issue in the lawsuit, like Isabela Ferrer was, then unfortunately you are going to have to comply with those things. If you're a non-party who's completely uninvolved, like 106 other people, then that's even more threatening, because people could just use subpoenas and depositions to kind of squeeze anything out of you, to embarrass and humiliate you, and then the public would know everything about it, because your privacy would not be something that would be considered. So when looking at people's requests to redact certain information, I want to look at it from the perspective of this is a non-party, and no matter who they are, their privacy should be handled with a lot of care. So look at these footnotes here. Because these exhibits include other non-party sensitive information, Ms. Ferrer is not submitting redacted copies of the documents at this time, so as to not inadvertently disclose information other parties or non-parties may seek to maintain under seal. Ms. Ferrer is prepared to submit redacted copies of these exhibits, reflecting the portions she seeks to maintain under seal at the court's request. This seems pretty reasonable and kind of responsible to me. I don't know if this is the same attorney who represented her last time with the filings or who did the writing last time, because the last one, when they were arguing about the subpoenas, was like, that was some crazy shit. But so far, I'm not, seeing anything insane here. 2, Ms. Ferrer's past filings with the court explain how she involuntarily became involved in this action when her private text messages were referenced in pleadings, and those filings demonstrate that while, it continues, Ms. Ferrer has discharged her legal obligations by appropriately responding to subpoenas or motions made by the parties, she has not voluntarily injected herself into the proceedings in any way. So again, just to summarize, I disagree that using the text messages in pleadings were anything improper or any form of harassment. However, I do feel like people do get harassed by others in the public who are reading this stuff. Somebody expressing their opinions about those text messages or the filings online, that's not harassment. But messaging Isabela Ferrer or anyone involved in this lawsuit and saying extremely hurtful or even threatening things, that is harassment. I think harassment is kind of a buzzword that too many people are now using to just mean somebody said something I don't like, even if they didn't say it to me or about me or whatever. Like that's not harassment. That's just freedom of expression. We all have people who say shitty things about us. It happens to me too. Sometimes it's bizarre, random, delusional crap that I see online, but unfortunately, freedom of expression, which I really believe in. I believe in freedom of speech. That's a hill that I'll die on. It means that people are going to say things about me that I don't like to. And as long as they're not forcing unwanted communication on me when I've explicitly asked them not to, as long as they're not intentionally sending me harassing or threatening things, I can't really do anything about that. You just have to kind of coexist with people who don't like you and people who don't like the things that you do or say. There are exceptions to that, like defamation, but defamation has a very high standard, and that's not really what we're looking at here. Negative opinions are not usually harassment or defamation. Even offensive opinions are not even usually harassment or defamation. They are, unfortunately, even if you're not a public figure, even if you're just a social media user online, they're unfortunately things that we just have to live with. So back to the document here. Such misuse carries an additional risk of professional harm to Ms. Ferrer, who is a working actress. Public circulation and potential distortion of intimate, highly personal testimony could negatively affect her opportunities within an industry that is uniquely sensitive to public perception. These risks fall squarely within the harms the court recognized in its memorandum and order, and they outweigh any minimal public interest in disclosure. And then they note here, courts may protect records from being used to promote public scandal or gratify private spite. And this kind of concept here is something that has been talked about a lot recently. Like, why does the judge allow the lively parties to do XYZ for press, and then the Wayfair parties get reprimanded for stuff? And my view of it was that the Wayfair parties are not asking the judge to admonish the lively parties, but the lively parties are constantly asking the judge to reprimand the Wayfarer parties. So I would say that has a lot to do with it, but that is just my opinion. So again, here, protecting records, like keeping these redactions to the unnecessary, irrelevant to the lawsuit information. That's, protecting her from things that would promote public scandal. Again, what's happened in the past as far as the subpoena and all that in of itself, strongly disagree that had anything to do with public scandal or private spite. If you refuse to respond to a subpoena or accept service, or you're dodging service somehow, which her lawyer would not accept service at the time, like it did seem kind of like she was dodging it, like that's not necessarily promoting public scandal. You have to then go to the court to try to resolve that. But again, my opinion. But protecting unnecessary information from being unsealed, released to the public to avoid public scandal, that makes sense to me, if it's really, truly irrelevant to the lawsuit and unnecessary. The requested redactions are narrowly tailored so as not to impede public understanding of the parties' arguments and the court's adjudication thereof. No broader sealing is requested. Sealing is necessary to, at a minimum, protect the following excerpts from Ms. Ferrer's deposition testimony, and then she lists those that we already saw above. So now, if no broader sealing is actually requested, then this does seem like a reasonable thing to ask. But again, we'll have to see if the Wayfarer parties or lively parties object to this in any way and why. This tailoring is fully consistent with the court's direction that continued sealing must be justified by specific on-the-record findings and restricted to information that qualifies under the court's framework. Maintaining sealing of these limited excerpts of sensitive testimony will not impede the public's ability to understand the motion for summary judgment, the opposition thereto, or the court's decision. The motion papers themselves remain publicly available with only narrow redactions, and the small portions of testimony at issue are not necessary for the public to grasp the substance of the arguments or the court's analysis, consistent with the court's recognition that material having no bearing on judicial function may be sealed, notwithstanding the strong presumption of access. In contrast, unsealing these intimate and highly personal excerpts would expose Ms. Ferrer to a significant risk of harassment and professional harm, a disproportionate consequence where the public's understanding of these issues would remain entirely unimpaired. When weighed, the balance here tips strongly in favor of sealing. For these reasons, Ms. Ferrer respectfully requests that the court maintain the sealing of, and then they ask for those documents again. All right. So personally, I feel, as someone who was a non-party who had to unfortunately kind of address the court in this case because of a subpoena, I think that this, like being able to request continued sealing and being able to ask the court not to release information that would be damaging to a non-party's privacy, their personal life, their profession, I think that's important. And I think that the subject of this letter, Isabela Ferrer, who's someone that, a lot of people who watch my channel are not in favor of, and I'm not crazy about how she acted either. I'm definitely not crazy about what her lawyer wrote when they were, upset about the subpoena. Not crazy about it at all. But I think personal feelings have to be set aside here in favor of something that impacts the bigger picture of our justice system. So we'll see how this plays out. Again, I don't know exactly what's in those excerpts. Nobody could, nobody who's not the parties or the attorneys who have seen this, if it's attorney's eyes only, none of us could know what it says. So we'll have to see if either the lively parties or the Wayfarer parties object to keeping any of this sealed. And then I guess we'll go from there. I expect to see more documents like this coming up pretty soon. Blake Lively herself will want to have some of that stuff that she sealed in her response to the summary judgment motions and the motion for judgment on the pleading. She'll probably want to keep some of that sealed. We'll have to see what that is. We'll have to see if any other non-parties come into the picture. But I just wanted to give my 2 cents on that as a non-lawyer who is just a member of the public interested in how our justice system serves the public at large. So, all right, guys, that's all I got for now. But thank you for watching, and I will see you all soon, probably live stream tonight. I don't know what the topic, though. I'm trying to branch out into some other things. Just, I don't know. I'm kind of discovering some different stuff that I'm interested in and wanting to talk about. So I don't know if it'll be related to this case or not, but we'll see. I'll probably see you guys later. Bye.